Assalamualaikum and very good day everyone. Today my group and I will present about the article we have choose. It is about the problem between Shangri-La Rasa Sayang Resort in Penang and their employees. From the article, we're gonna look what are the concepts related, what was the problem, which parties is involved, how to manage the issues, and what can be concluded. Okay, let's take a quick recap of what is industrial relation and what is trade union. Industrial relation is a field of study that examines relation between employers and employees, while trade union is an organization formed by a group of workers in order to protect employees' rights. Next, we're gonna look what are concepts or subject matter related to the content. The first concept is trade union in Malaysian public or private sector. Second concept is collective bargaining and collective agreement. The third concept is the trade dispute and industrial action. Now we're gonna look what are the problem and issues from the article. The first problem is Shangri-La refused to honor the existing collective agreement between them and their employees. The second issue is National Union of Hotel, Bar and Restaurant Worker launched protests due to termination of collective agreement and took the case to the industrial court. The third issue is Shangri-La unilaterally imposed the new terms of employment to assert their power. Based from the article, there are three parties involved. The first one is the employers, which is Shangri-La Rasa Sayang Resort and Spa. The second one is their employees. And the third party is National Union of Hotel, Bar and Restaurant Worker.
There are three concepts that are related to the article we have chosen to the chapters of ADS465, which are trade union in Malaysia, public or private sector, trade disputes and industrial actions, and collective bargaining or collective agreement. The first related concept is trade union in Malaysia, public or private sector.
Trade union is defined under Trade Union Act Section 2 as an association of workers or employees set up within particular trade, occupation or industry.
In public sector for employees union, workers are in the same ministry, department or occupation and is not involved in collective bargaining. Wages and other terms of services are discussed at the national level between government and QPEX. For private sector employees union, it is divided into national and in-house unions. National unions covers all workers in the same industry, trade or occupation. In-house unions are members that are all employed by the same employer. The second related concept is trade disputes and industrial actions. Trade disputes is defined by Section 2 of the Industrial Relations Act as any disputes between an employer and his workmen which is connected with the employment or the non-employment or the terms of the employment or the conditions of work of such workmen.
As you can see on the screen, these are some of the causes for trade disputes.
There are four methods or steps to settle the trade disputes, which are direct negotiation, conciliation, mediation, and arbitration. Industrial action is when a trade dispute exists. A trade union may take industrial action to force an employer to give in to its demands. Industrial action by a union of employees may be in the form of a picket or an strike. The third related concept is collective bargaining and collective agreement. Collective bargaining is defined by Industrial Relations Act 1967 as negotiation with a view to the conclusion of a collective agreement. There are 5 objectives of collective bargaining. Number 1, to improve wages and conditions of work and employment among employees. Number 2, to protect employees' welfare. Number 3, to avoid arbitrary action by employers. Number 4, to involve employees in decisions making. And number 5, to avoid unilateral decisions. The process taken for collective bargaining is: firstly, trade union submits in writing a proposed collective agreement to an employer and invites to begin negotiation. Then employer must reply within 14 days. If the organization agree, bargaining session must start within 30 days of the agreement. In the case of the employer refusing to negotiate, union may inform Director General of Industrial Relations and request for conciliation. This is when trade dispute arises. But in the case of when the employer agrees to negotiate, representatives of workers and employer will meet for a few sessions until acceptable compromise is reached. Agreement will be put in writing and signed by both parties. There are two contents of collective bargaining which are bargainable and non-bargainable. Collective agreement is defined by the Industrial Relations Act 1967 as an agreement in writing concluded between an employer or employer union on the one hand and an employee union on the other, relating to the terms and conditions of employment and work of workmen or concerning the relations between such parties. The contents of collective agreement is: must specify the name of the parties to the agreement and the duration for which the agreement is to be effective, which is not less than 3 years. It also prescribes the procedure for settling any question over the interpretation or implementation of the agreement. The contents of collective agreement shall not contain any term or condition of employment less favorable than or in contravention of the provisions of any law applicable to the workmen covered by the agreement, which is, any such term or condition shall be void and of no effect to that extent. The requirement of collective agreement is: number 1, the collective agreement must be in writing and signed by the parties to the agreement or by persons authorized on their behalf. Number 2, a signed copy of the collective agreement must be jointly sent to the registrar of the industrial court within 1 month from the date on which the agreement has been entered into for granting a cognizance.
So now we're going to relate the concept that we had studied with the issue from the article. Based on the previous slide, our group had decided 3 types of concepts, which is trade unions in Malaysian public or private sector, second, collective bargaining or collective agreement, and the last one is trade dispute and industrial action. For the first concept, which is trade unions in Malaysian public or private sector, there is an issue in the article which when National Union of Hotel, Bar and Restaurant Worker launched protest due to termination of the collective agreement and took the case to the industrial court. In addition, this issue and concept can be referred based on the law of Malaysia and the Trade Union Act. Next, there is an issue which when Shangri-La refused to honor the existing collective agreement between them and Rasa, Sayang without employees. This issue is related to the concept of collective bargaining and collective agreement. Moreover, the concept and the issue can be referred to the law of Malaysia under the Employment Act. For the last concept, which is trade dispute and industrial action, there is an issue which when the Shangri-La unilaterally imposed the new term of employment to exert their powers. For this issue and concept, this can be referred to the law of Malaysia under Industrial Relation Act.
Moving on to my part, there are 3 suggestions and recommendations to manage the issue discussed, which is trade union, collective bargaining, and arbitration mechanism. Every employee should have joined any trade union regarding to their job, as trade union provide many types of benefit. Joining trade union can help you to improve the employees' terms and conditions, to protect rights as employees, and to satisfy their social needs. As you can see in the slide, there are many objectives of trade union. The first one is to protect interests of its member, to regulate the relationship between employees and employers, and to conduct collective bargaining, to represent the employees in trade disputes, to represent the employees in the courts, to undertake activity as promote social, recreational, and cultural activities among its members, and to promote or organize any legitimate industrial action, including strike, subject to provision, Trade Union Act 1959. According to the article that we chose, we can see that Shangri-La, Rasa, Sayang resort and spa workers have become the members of the IUF-affiliated National Union of Hotel, Bar and Restaurant Workers Peninsular Malaysia, NUHBRW. It shows that the employees have joined the trade union. Next is collective bargaining. It is the process of negotiations, the terms of employment between an employer
Since the
and a
collective
group of
bargaining is
workers. Unsuccessful, thus it leads to trade dispute. Industrial Relations Act has met three methods to settlement of dispute, which consists of direct negotiation, conciliation, and arbitration. Shangri-La workers returned to the work at the renovated hotel and found out that the wages and benefits under the existing collective agreement is no longer applied. Arbitration is where an impartial third party is given the authority to settle the dispute by examining the information given by both parties and making a judgment. Industrial Relations Act 1967 identified one agency for arbitration of trade dispute, which is Industrial Court. The powers of the Industrial Court, Section 29 Industrial Relations Act: power to summon, join, substitute or strike of parties, take evidence on oath of affirmation, compel for books, papers, documents, and other things deemed necessary, conduct proceedings in private, call in the aid of experts, do all such things to expedite the matter before it. NUHBRW members launched protest actions against the unilateral termination of the collective agreement and took the case to the industrial court. When a trade dispute has taken place, trade union may take the industrial action to pressure the employee to have the intention towards the employee's demands. Industrial action that can be done by the employees can be in the form of picket or a strike. The causes are the failure of peaceful dispute resolution methods, the attempts of a party to force the other party to give in, and employers and employees' attitudes such as intolerable. Finally, in April 2017, the Federal Court upheld the Industrial Court decision and ordered the Shangri-La to restore the terms and conditions of collective agreement retroactive to 2006.
As a conclusion, the issues from the article is regarding Shangri-La unilaterally impose the new terms of employment to assert their power. The second one is National Union of Hotel, Bar and Restaurant Worker launched protest due to termination of the collective agreement and took the case to the Industrial Court. And the last one, Shangri-La refused to honor the existing collective agreement between them and Rasa Sayang resort employees. When there is harmonious relation, it can influence employees' morale, better productive of the employees and improve company's performance, reduce conflicts at the workplace, avoid industrial disputes through mutual understanding and cooperation, and lastly, ensure economic growth through the productivity of employees and the industry. Okay, that's all from our group. Thank you.